Nigeria. And today we're talking about a petition by the federal government to proscribe the Islamic movement of Nigeria, IMN. So last week, the federal executive approached the Federal High Court in Abuja with an ex parte for the right to proscribe the IMN, an ex parte motion. The court granted the motion, and after that, the Inspector General of Police announced that the group has been proscribed. And today's big hard fact, I never start this without sharing a big hard fact with you. Here's today's big hard fact. Since the Terrorism Prevention Act, TPA, was passed in 2011, the federal government has banned 4 groups under its provisions: Boko Haram and Ansaru in 2013, IPOB in 2017, and IMN in 2019. Now, the IMN is challenging the proscription order in court. It has filed a motion with the Federal High Court in Abuja asking it to set aside its ex parte order. The IMN is basing its motion on 3 grounds. Number 1, that the court lacks the jurisdiction to issue the ex parte order against an entity that is not registered. Number 2, that the order breached the fundamental right of all its members to fair hearing, guaranteed by Section 36 of the Nigerian Constitution. And number 3, that the ex parte order violated its members' rights to freedom of thought, conscience, and religion. So right now that matter is in court and we're waiting to hear whether the proscription will stand or not. But today, let's talk about the whole issue, proscription itself, and whether it is constitutional. And if it is, let's talk about whether or not the IMN's activities have crossed the threshold to deserve proscription. We're also going to be talking about what this proscription means in practical terms. And we're going to like hearing from you on Facebook, on the phone lines. Facebook is Nigeria Info FM. Our phone lines are 01277 0993. We want you to tell us if you agree with the decision to proscribe the IMN. Do you think banning a group is an effective strategy? Do you think it is proper? We're going to be taking your calls at particular times, but throughout the show, send us WhatsApp messages at any time. 080-959-75805. 080-959-75805. Joining us is Professor Chidiodin Kalo, who is a human rights activist, a human rights lawyer, former chairperson of the Nigerian Human Rights Commission, and he's on the show with us today. Hello, sir. Thank you for joining us.
Hi, Auntie Sandy. How are you?
Sandra is just fine.
Thank you for having me.
Yes, of course. We also have Buki Shonibare, who's also a human rights activist and human rights lawyer on the show. Hello, Buki. Thanks for joining us.
Thank you for having me. Good evening, Dr. Dinkali.
Good day, my sister. How are you?
I'm fine, sir.
All right.
Thank you, Sandra, for having us.
Yes, of course. Let's get right into it. So, proscription is the banning or outlawing of a group. Under Nigerian law, it is illegal to be a member of or be associated with a proscribed group. This offense carries a 20-year prison term. Am I correct?
Well, it depends on what law you're citing.
Exactly.
Oh, I see. So let me ask the lawyers what it is. What is proscription?
Buki? Because I don't claim to be a lawyer anymore. So
Okay. So let me talk to Buki then.
Okay. Started rigging elections, so I no longer claim to be.
Yes, the professor always says that I'm not a lawyer until Nigerian Bar Association started rigging elections. So let me come to Buki. Buki, help me out.
Okay, so thank you. I do not claim to be a professor like Dr. Dinkali. So I'm going to constantly defer to his superior thoughts and decision, so to speak. So to prescribe, just like you said, means to forbid or to denounce. And in this case, we're going to be streamlining mainly to the IMN.
Yes.
And of course, we can then begin to discuss whether the IMN can be prescribed, considering that they are not a juristic body.
I see.
But then, like Dr. Dinkali had said, it depends on the law that you're actually saying, using. In this case, we are discussing the Terrorism Prevention Act.
Okay.
And when you look at Section 2 of the Terrorism Prevention Act, you would see the context it has given to prescribing organizations.
That's right.
So basically, what the Terrorism Prevention Act is saying is, once a group or organization meets everything that was stated in that Section 2 of the TPA, 2011 in this case, then that group is proscribed. That means it's denounced, it's forbidden, from carrying out its activities. Let's not also forget that the 2013 Terrorism Prevention Amendment Act further expanded, what sort of organizations can be prescribed as a terrorist group. So to answer that question succinctly is to say proscription is about forbidding and denouncing a group. And in this case, it's that of terrorism. And Section 2 of the Terrorism Prevention Act 2011 has described what sort of organization can be prescribed as a terrorist group. And sorry, let me just quickly add also. So once an organization is prescribed as a terrorist organization, it gives the government the permission, quote and unquote, to then be high-handed with that particular group. So you begin to treat that group as one that is engaged in illegal activities, that is considered to be inimical, or dangerous to the nation as a whole.
Now, it's interesting that you mentioned the TPA, that's the Terrorist Prevention Act. I found something very interesting, especially when you look at subsection 1B. It says that this is intended to, 1, unduly compel a government to perform or abstain from performing any act. 2, seriously intimidate a population. So, Professor Dinkalo, can an argument be made that the protests and marches by the IMN are either unduly compelling the government to release Sheikh El-Zakzaky or intimidating the population?
How do you... The question, I guess, is all of this is academic in many ways. But the question would be, how do you compel or intimidate a government? Don't forget, under basic international relations doctrine and law, as a matter of fact, the government, presumptively at least, has a monopoly of the legitimate instrumentality of violence. Correct? So that is why we maintain an army, police, security services, SSS, uniform services, customs, the lot. We arm them with a lot of guns and ammunition. That's considered lawful, and nobody would quarrel with soldiers carrying out ordinarily. Now, in 2015, December, the army absolutely raised the assets, the headquarters and everything, the Husseiniya, the headquarters, the residence of Zakzaky in Gielesu. They killed hundreds. According to the group itself, they killed over 1,000. Not one knife was recovered. Yes? The army, you see, this is a country in which the police, the armed forces would arrest a few people and say, oh, we found these guns on them. Does anybody tell you that when they destroyed all those things, they recovered one knife? They did not. And all the arms that anybody has ever found on the IMN have been what? Their hands, their hijabs, maybe one or two kids throwing stones at the very worst. So how do you intimidate a government that is armed to the teeth with bazookas and Air Force and the Navy and you name it with stones? Can you please answer that question?
Well, if you come back to subsection 1, to section 1, subsection 1C, it has other definitions of acts of terror. There are 2 that jumped out at me. So 1, an attack upon a person's life, which may cause serious bodily harm or death. And 3, destruction to a government or public facility, likely to endanger human life or result in major economic loss. At the last protest, the government accused the IMN of killing a police officer and also of destroying a bus. Do these allegations not fall under the scope of acts of terror as laid out in the TPA, Professor Dinkalo?
Sandra, I really hate to get into this because human life is very important.
Yes.
And the police officer killed was an asset on national service. And his family does deserve some support and peace.
Yes.
And so I am leery about getting into this, very honestly. But let me suggest this to you.
Okay.
If you notice, that police officer was killed by a bullet to the head. An automatic, almost certainly an automatic. It went in just above the ear and came out just by the back of the head. Yes? One bullet by protesters in a protest to the side of the ear. My sister, anybody who knows one line about ballistics will tell you that is not a protester's bullet. That is all I can say.
Okay. Let me come to you, Buki. According to the TPA, to proscribe an organization, the Attorney General or the National Security Advisor or the Inspector General of Police simply has to approach the court and make an application, right? The judge is allowed to proscribe the group at that point without a trial. Now, I have to ask you, is it constitutional for an organization or a person to be declared guilty of a crime, in this case terrorism, without a trial? Can the court issue a criminal punishment, proscription, without a trial?
No. It is against the law. It is unconstitutional. And when we are talking about the constitutionality of this case, we are looking specifically at Section 36 of the Constitution of the Federal Republic of Nigeria, as amended. When you look at that provision, and I'm going to quote specifically subsection 1, it says every individual shall have the right to have his cause heard. This comprises the right to an appeal to competent national organs against acts of violating the fundamental rights as recognized and guaranteed by conventions, laws, regulations, and customs of force, and every other thing that was said. It then went on to subsection 2 to say that no one may be condemned for an act or omission which did not constitute a legally punishable offense at the time it was committed. So let's not go into that. By Section 36 of the Constitution, it gives a right to all parties in a suit to be fairly heard. So you cannot prescribe an organization to be a terrorist organization when you have not heard from that other organization. And this ties back into the means that was used, an ex parte order. Now, by an ex parte order, it means that, when you look at the meaning of ex parte simply means on one party.
Okay.
Here, you are looking at, in cases of urgency or emergency situation, whereby there is need to restrain a party from doing an act, which, if not done, would cause irreparable damage to the other party. Now, the party that is requesting it. Now, are we saying that we are just knowing about the activities of this body called the Islamic movement in Nigeria? We are not just getting to know. So it's not just an activity or a group that just came up, and we need an urgent ex parte order such that denies the other group. You want to prescribe us as a terrorist organization. You did not give us the opportunity to come and say all of the elements that is being said regarding us is actually good for you to say, okay, yes, we are a terrorist organization. Sandra, let me take you back a bit. Permit me.
Okay.
Section 1, subsection 2 of the Terrorism Prevention Act of 2011.
Yes.
Part of the element that was stated there was malice afterthought. And by the definition of malice afterthought, you are looking at an important an intention to kill or harm, which makes it different from murder or unlawful killing.
I see.
Can we impute that this group, who, let's not forget why they are coming out, is to protest for their leader and the wife, Zinat, who has been in custody since 2015 to ask that they should be released. Can we say a protest for that can be imputed as malice afterthought, which is intended to kill or something? So all of these trying to look for reasons to justify calling this group a terrorist group is really not necessary. So just to answer your question, is to say that it is unconstitutional, it is against Section 36 of the Constitution. It is also against Article 7. You know, Nigeria is signaling, African Charter on Human and People's Rights. Yes. We have the Ratification and Enforcement Act of the African Charter, and Article 7 of that particular law actually, also speaks on fair hearing. So it is unconstitutional.
Now, do you believe, Buki, that the Terrorism Prevention Act is fine as it is? Or do you think an amendment is needed to require a conviction for the terrorist acts that it lists before a group can be proscribed? Is the burden of proof too light?
Yes. I think that the Terrorism Prevention Act, and this takes me to Section 1 or Section 3 of our Constitution, which basically says that when you have a law which is inconsistent with the Constitution of the Federal Republic of Nigeria, it is to the extent of its inconsistency null and void. So when you have a Terrorism Prevention Act that gives the Inspector General of Police, that gives the National Security Advisor and the Attorney General the permission to go to court, use a particular order, whatever, even though the TPA did not state that an ex parte order should be used. Use that, whatever is the power and authority they have, to prescribe a group as a terrorist group without due recourse to fair hearing, Section 36 of the Constitution. It means that provision is to that extent inconsistent with the Constitution. So I think there is need for amendment, especially like we are identifying now, needs to hear both parties before you can rightly prescribe them.
Okay. Well, if you just joined us, good evening to you. You're listening to Hard Facts on 99.3 Nigeria Info. I'm Sandra Ezekwesili, and we're having conversations with Professor Chidiodun Kalu and Barrister Buki Shonibare. She just wants me to call her Buki. Buki, I'm sorry about that. And we're talking about the IMN proscription. We're taking a look at it. We're taking a look at the law of it. We're taking a look at the letters of it. And Professor Dinkalo, the IMN has filed a motion to overturn the proscription order. As I said when I was introducing the show, they're making three arguments, and I want us to look at each of them. The first argument is that proscription of a group violates its members' rights to freedom of thought, conscience, and religion. What's your take?
Now, Sandra, I told you I failed as a lawyer. I'm not I don't.
Yes, but you're commenting as a social commentator now.
This is not my bailiwick. And if you notice, I've concentrated on facts.
Yes.
I don't think the medium of radio is a place where I can come to argue law anyway, even if I had the skills to do so.
Yeah.
So, first of all, you see, they talk about whether you're talking about the Constitution or the TPA or whatever. There are some basic things about these matters that don't require you to cite much law. Number one, the TPA, that's the Terrorism Prevention Act, does not empower anybody to proscribe anybody without fair hearing. That's the point that Buki has been making.
Yes.
Yeah. But then we're in a country in which the Chief Justice of the Federation was fired by an ex parte order procured from the
CCT
Code of Conduct Tribunal. So we are an ex parte country now. You don't even have to show up. You don't have to be asked any questions to be confirmed as a minister. So hearings don't make sense to us as a method of government at the next level these days. But what? Number two, you, as a matter of basic common sense, not even law, you don't give orders against people that don't exist as law. Right? So this case when you read the order was made against IMN, Islamic Movement of Nigeria, by howsoever called. Now, there is no entity registered as Islamic Movement of Nigeria. To acquire legal personality in Nigeria, there's a way you do that. You've got to be incorporated under the Companies and Allied Matters Act, under one of the parts of the Companies and Allied Matters Act. IMN has never been registered in Nigeria, does not have legal personality. As a matter of law, you cannot issue binding legal orders or go to court to sue an entity that is not a legal person. IMN simply does not exist at law. It is only military rulers that issue decrees against entities that don't exist. So what have these people done? In order to procure this order against an entity that did not exist, they would have had to first give IMN legal personality in order to require it not to exist anymore. That has not happened. The whole thing does not make sense. Number 3, as a matter of fact, IMN is one of the most litigious entities in Nigeria. Everything that happens, they go to court. How many terrorist organizations will be suing you when they can shoot you and bomb you? I don't know whether you get me.
Yeah.
Their chief lawyer is Festus Okoye, whom this particular government appointed as INEC National Commissioner. They have Maxwell Kion in Kaduna as their lawyer. They have Femi Falana in Lagos as their lawyer. As I speak to you, they've got 5 court orders against the federal government that the federal government has refused to obey. They have also got judgment debts against the federal government running into millions of naira that the federal government has refused to obey. When you sit down and procure the proscription of people who owe you money, of people whom you are owing money, that is abuse of power. So I'm not going to start arguing law here for you. The facts are damning enough without having to abuse the law.
I see. Buki,
let me add to that.
Yes, go ahead.
Sandra, if you would permit.
Go ahead, Buki.
And it's just for me to use the example of the Bring Back Our Girls.
Okay.
In 2014, CP Oboh came up with a public notice banning the activities of Bring Back Our Girls and preventing us from meeting. And we went to court. When we were going to court, we and at that time, Femi Falana was also a lawyer. We did not go as Bring Back Our Girls. Why? Because we were not recognized as a juristic person, as a juristic body or entity by law. The law does not know us.
I see.
Even though we were going about as hashtag Bring Back Our Girls, it's just to corroborate what Dr. Odinkalu has just said. We could not, despite the fact that, there was already a globalization of the campaign, everyone was talking about it. It did not make us a legally recognized entity. Why? Because we were not registered according to Section 38 of the Companies and Allied Matters Act. That's number one. To that question that you also asked, Section 38 is clear of the Constitution to say that every person shall be entitled to freedom of thought, conscience, and religion. I know Dr. Odekadi does not want us to quote many laws, especially because, the facts are clear. But we cannot but keep going back to the tool that we have. And I will keep, coming to the Constitution, which is our ground norm. Section 38 is clear that every person shall be entitled to their thought, conscience, and religion. This is their thought, this is their conscience, this is their religion. If you go to sub 3, it says no religious or community or denomination shall be prevented from providing religious instruction for purposes of that community. Why we got here in the first place, and the massacre of 2015, which even led us to this point, is the fact that these groups are being prevented from conducting their education. Now, whether what is being taught is against your own belief as a Muslim, as a Christian or something is another thing entirely. But see, where one's right stop is where another right begin.
Yeah,
so
but
we must not stop. Yeah, go ahead.
But I have to ask, because you've said that Professor Dinkalo said that they are not registered in Nigeria. As far as the law is concerned, they don't exist. How then are they able to file a case in court? Now, you said that as Bring Back Our Girls, you were able to go to court, but you didn't go as Bring Back Our Girls. Now, in the case of the IMN, if someone is going to court for IMN, doesn't that violate their proscription? Isn't going to court in the name of IMN now a crime, Buki?
Sandy, what Dr. Dinkalo has said is clear. He's saying that there is currently no legal entity called IMN that is registered. So even the proscription is null and void. It is baseless. You can't place nothing on you can't place something on nothing and expect it to stand. There's nothing that is standing here. Why? Because this group is not recognized by law. Agreed that when they are now appealing, or so to speak, they filed a motion on notice now. You will notice the careful use of members of the group, even though there was also the use of IMN. But let's not forget that there is currently no legal entity called IMN. So even the proscription is like prescribing nothing, because nothing like IMN exists.
I see. Now, I want to talk to you about the law. Professor Dinkalo doesn't want to talk about law, so let me talk to you, Buki. Let's talk about ex parte motions. I want you to explain to my listener what they are and why they are meant to be given. You've said it before, but say it again for reinforcement.
So whatever I say, don't forget that Dr. Dinkalo, even though he doesn't want to discuss law, is still my professor.
Yes, of course.
I'm still going to be far. So an ex parte motion basically is used for emergency situation. It's a judicial proceeding where one opposing party goes to court to receive an order from the court, so that the court can either prevent an act or ensure that there is a kind of protection for that party that has gone to court. So I will give an example. Like I said earlier, ex parte means on one party. So that means the decision that is being made is made on all that one party has come to court to say and claim. It is often needed for urgent or emergency situations.
Was this an emergency situation? I mean, was there a pressing need that called for hearing this case without them being present?
See, don't forget that what the ex parte motion, what they went to court for this ex parte motion is to prescribe that group of people as a terrorist organization.
That's right.
And that in itself is not an urgent situation. And it is not one that if you do not do it, it will cause irreparable damage to another party. So now, often when an ex parte motion is filed, a motion on notice is filed. Note that when the lawyers to the federal government did not file a motion on notice. Now, what the motion on notice will do, in contrary to an ex parte motion, which is urgent and immediate, and without hearing the other party, is that the motion on notice then gives the party the permission to make an application for the court to give a ruling in a particular situation. And you know what goes into getting a ruling. So that means you're calling witnesses, and all of that processes. And in this case, fair hearing is guaranteed. So it's not like just one ex parte motion where you are not even giving recourse to the perspectives and the claims of the other party. So that's the difference between when you are issuing an ex parte motion. To say again, it is on the claims and the gist of one party, as against a motion on notice, which then gives permission for both parties to be heard before a decision is made. But often an ex parte motion is interim. So that means even when it has been granted, it is pending the final determination of a suit, which is why a motion of notice is then required once an ex parte motion is filed.
I see.
I hope that makes sense.
I see. Yes, it does. Thank you very much. Now, Professor Dinkalo, at his ministerial confirmation before the Senate last week, you mentioned that earlier. That's why I remembered that question. Former Attorney General Malami said that court orders have been ignored in situations where national security conflicted with individual rights. And he used the Asari Dokubo Supreme Court case as his backing. I want to ask what your interpretation of that ruling is and if it gives power to the executive to ignore court orders.
You clearly didn't hear me. I will not be arguing and discussing anymore here. Because it's quite honestly a waste of time.
Well, it's for the benefit of my listener who will call me and argue with me.
If I stand up here, wherever you think I may be, and I am discussing about an Attorney General of the Federation telling the Senate that he disobeyed court orders deliberately, and the Senate is clapping for him and confirming him, I'll be very stupid. And you want me to take that law seriously? I'll be really, really, truly stupid. I know I'm usually very stupid, but not that stupid. So I will not be discussing any of that. If Nigerian citizens want to run our country like that, we'll get the country that we deserve. Yeah? But, so I want to get back to ex-party orders are not dispositive in a final sense. You see, again, I don't need to cite cases or law to make this point. The Yoruba people say what? You don't shave a person's head in their absence. African proverbs explain these things better than me telling people who are on radio, section this, paragraph that. How do you shave a person's head finally in their absence? But you can get an order saying, bring your head so we can shave it. Are you there with me?
Yes.
That is the difference between an ex parte order and a motion on notice, or an ex parte process or a motion on notice. So, an ex parte process enables you to prepare to do proper adjudication. So, if you read the Terrorism Prevention Act, what it does not anywhere in that act authorize a court or the Attorney General or the NSA, the National Security Advisor, or the Inspector General of Police to apply for the ex parte proscription of any entity. However, they can apply to get a warrant of arrest, ex parte. They can apply to get a search warrant, ex parte. They can apply to for interim seizure of assets allegedly connected with terrorism. They can take steps that would help investigation or help protect the public on an interim basis while proper measures are being taken. What they cannot do as a matter of law is to end the rights of people by means of ex parte process, effectively asking a court at the instance of the federal government to shave somebody's head in their absence. That just they cannot do. And in any case, why would the law matter if after you have gone to court, as I told you, the people connected to the IMN in different guises have at least 5 orders against the federal government. The federal government has chosen not to obey any of those.
Do we know why?
You have to ask the man who has just been confirmed as Attorney General. He has the power. He can do it because he's God. That's the only way I interpret it. So why I would argue law with that kind of, because there is no law. You see, the problem with this is very straightforward. There is no law that would make sense to people who want to be God on earth.
I want to tie this with what's currently happening with the Sowore situation, Professor. The DSS arrested Omoyele Sowore, publisher of Sahara Reporters, presidential candidate in the last election, for treason because of his planned revolution protests. What's your take on that?
I don't understand why anybody would arrest anybody for saying they want to organize a Revolution Now demonstration. I frankly don't. You see, the thing is, government always makes the same kinds of mistakes over and over and over and over and over, and you think people would learn? In all likelihood, if Sowore had been left to frustration, he may have turned out a few hundred, maybe some thousands, and then that is it. It would have petered out. And the limits of his mobilizational capacities would have been shown up. And in 1 or 2 days, everything would have died down. Now, what do you notice? Everybody is talking about Sowore, but government just lost its nerve, and by losing its nerve, allowed itself to lose the argument. And for those in Abuja, today it rained, from what I understand, rather quite fulsomely.
Yeah.
So, and if it rains, the likelihood is that you're not going to turn out lots of people. You may turn out the absolute diehard, but you're not going to turn out too many people for a demonstration. By losing its nerve, the government has quite clearly shown it does not have an argument. But let me say one more thing.
Mm-hmm.
You're having all this massive show of force, police officers and soldiers in camouflage and automatics, submachine guns on the lot, and they're all taking over different parts of the country to do what? To shoot Nigerians who want to throw stones at worst. But none of the people whom I saw today, from wherever I have been, has carried any stone. And yet, this is a country in which Boko Haram has been killing a lot of people, no show of force there. Kidnappers are killing people in the south, as far as the southwest, no show of force there. Militants are running amok in the Niger Delta, you don't have any show of force there. Armed herdsmen are in the middle belt, no show of force there. Bandits are in the northwest, they are running away. And the people they want to shoot are the Nigerians who are least dangerous. Are we normal? Is this proper?
Okay, Buki, let me ask you. I have some quotes here from Showore's press conference announcing the protest, right? I want to read them for you and ask you if you think they crossed the line or if they're still covered by free speech. And Professor Dinkalo can also weigh in if he wants to. He said, quote, "Revolution is inevitable. They made it inevitable. Nigerians have no faith in the ballot box. It is time to take it to the next stage. There must be a showdown." And then he goes on to say that Nigerians have to, quote, "bundle these guys out," end of quote. Isn't he saying that there must be a showdown that will not take place at the polling unit and which will result in regime change? And if that is the case, Buki, isn't he talking about subverting the constitution? Isn't this overthrowing the republic?
Okay, so if you would permit me, I've not really been following this because I have just returned from it. So I've not followed it as much as I should.
Okay.
But then I know that from the little conversations that I have had with few friends on this, again, I'm careful to speak authoritatively on this because I've not followed it closely.
Okay.
So I was going to ask you to excuse me on this.
Oh,
but
I see.
just from the few conversations that I have had with people, the argument has been on the basis of revolution and protest. And those who believe that, a revolution is a way of taking over the government, the question is, what is the substance of what is to be done against what is being perceived as what is to be done? If what is to be done by Sowore is a revolution, we know from what we have heard or what we have seen is that there is going to be a peaceful protest, which is within the right of any Nigerian. But if the contextualization of what is to be done is revolution, then it gives it another face in comparison to what a peaceful protest is. But I would have been able to make very strong points on this if I have followed it very closely. So if you would permit me, I would defer to Professor Odinkalu on this, because I presume he has followed this, and it will also be a point for me to understand better what is going on and to learn.
All right, Professor Odinkalu.
Ma?
I want to hear your thoughts. These words from Sowore, do they cross the line, or are they still covered by free speech?
What line?
The line where he's currently being accused of treason.
Yeah, I'm saying what line? You don't commit treason by words. You have to follow them up with some action. Words are not treasonous. You see, words can be defamatory. Right?
Okay.
Words alone can be defamatory.
Okay.
The point is, so a man is supposedly planning to overthrow the government. You go and you take him from his house. He doesn't even have a knife. He does not have a bow or an arrow. You can't find a gun on him. You don't even produce a cassette. Where is the treason? This is the proof. There's a lot of hyperventilation about these things. And democracy is messy. Democracy can be robust. Democracy can be nasty sometimes. Right? But there are also clear lines. You're using the word lines, and I've seen red lines, some releases from different people. But the lines are fairly clear, it seems to. You see, if this were a country in which law matters, the lines are very clear. You don't talk about treason without it is called overt act. There has got to be something additional to mere words. All Sowore did was it will be called psychological operations. He used the word deliberately knowing that some people were going to hyperventilate, and those people played into his hands. He's outsmarted them. Now, this is a government that's just won electoral legitimacy, at least according to their narrative. And you would expect, if I've won the kind of election that President Buhari has won, and the person who ran against me and scored fewer than 100,000 votes, according to the official record, is coming out to say he's planning a revolution, I'll go into the bathroom and have a good laugh. I'll sit down in my dinner table and have a wonderful laugh. So there is something either flawed in their claim of legitimacy, or they are just fundamentally insecure. That's the only way I can put it.
But Sowore said, don't ask me if I'm afraid of the legal implications of this. Only history can judge me. I know we say that they are words, but aren't these the words of a man who knows or believes he's breaking the law but no longer cares?
What is the act that Sowore has done? Where is the overt act?
I see.
Look, you see, they can hold him as long as they wish to and feed him for free as long as they wish. They know, the only reason they will do that is they know they cannot sustain any charge before any independent tribunal or court. There is no overt act.
All right, so let me tie it back to this, our main conversation for today in wrapping up, which is the proscription of the IMN. One of the accusations that the government has leveled against IMN is that they do not recognize our system of government, Professor Odinkalu, and do not...
has gone to court. How many times does not recognize your system of government? How many times has the IMN gone to court? Is the court not part of government? No, I will not allow you to finish that question. Because this is El-Rufai's propaganda. They don't recognize our system of government. Did they go to court in Iran? Or did they go to court in Saudi Arabia? They went to Nigerian court. It is the Nigerian government that refuses to obey orders of its court, because the Nigerian government is run by people who have a sectarian agenda against the IMN. This has nothing to do with Nigerian law. And that's why I refuse to argue Nigerian law with you. Because this is a sectarian agenda, and we've got to call it what it is. You're saying IMN, who have gone to Nigerian court and got orders from Nigerian judges against the Nigerian government, subscribes to a foreign government. Really? And now, the same government that has declared IMN a terrorist organization is going to be exporting a terrorist according to their law, who is Zakzaki to another country? Which country will accept a terrorist? Do we reason at all? How do you declare a group a terrorist organization and then come up with an order to take their leader out of the country? Who is going to give him a visa?
Important points being made on the show today. Professor Dinkalo, thank you so much for your time. Buki, do you have last words as we say thank you for joining us on the show? Go ahead, Buki.
Yes, please, I do. And it is taking us back to Section 2 of the Terrorism Prevention Act of 2011.
Okay.
And that is just to make my final point on the need to amend this provision or this particular act based on what the Constitution has said. I am one of those who believe that the Constitution is our problem, but this is not the time for that conversation. And it is to look at Section 2, subsection 2, Section 2, subsection 1. And if you permit me, it says, to prescribe an organization, it says, where two or more persons associate for the purpose of or where an organization engages in participating or collaborating in an act of terrorism, that is A. B. Promoting, encouraging, or extorting others to commit an act of terrorism. Or C, which is where I now want to emphasize on, setting up or pursuing acts of terrorism. The judge in chambers may, on an application made by the Attorney General and all of these people, what application? I guess this is what gave these people the permission to go and use an expertise. To apply so that they can get a quick and urgent judgment against these people. And if you go down to Section 40 of this TPA 2011, the interpretation section, it did not contextualize certain words, that would help us understand better why they are trying to use this law against a particular group. My concern is if we allow this to fly, that means once the government has a problem with another group tomorrow, they can be easily prescribed as a terrorist organization.
Exactly.
And once you prescribe a terrorist organization, it gives you the permission to use guns and on them. We must not allow this to continue because it could be IMN tomorrow. Let's say they are a body that exists. It could be another body tomorrow.
Okay. Well, Mike says that any group that will stop an army chief and a governor from passing through where they based, such group is far more than a terrorist. I'm pretty sure Professor Dinkalo is not going to respond to that.
Come on.
No.
Okay. Thank you so much, Professor Dinkalo and Buki Shonibare, for joining us on Hard Facts in Lagos.
Thank you, Sandy, for having me.
Okay. All right. So Buki Shonibare and Professor Dinkalo are both lawyers, professor of law of Dinkalo himself, and a human rights lawyer, Buki Shonibare. Thoughts that they've been sharing on the show. I've got so many comments, and I will try as quickly as I can to take them after this break. You're listening to Hard Facts on 99.3 Nigeria Info.
99.3 Nigeria Info.
Welcome back to Hard Facts.
We've got 5 minutes left. Let's see how many calls we can squeeze into that. 012770993. I want to hear your thoughts about the interview and the conversation that I had with Professor Dinkalo and Buki Shonibare. 012771992, 012772993, and 012773993. So 012770993, 1993, 2993, and 3993. Oboh is next. Hello, Oboh. You've got 30 seconds.
Yeah, Sandra, good evening.
Yes, go ahead.
You see, I'm very glad hearing the professor today for all of his submissions. They are quite perfect. I mean, perfect.
Okay.
It's just to tell you that, when government does not know its purpose, abuse is quite inevitable. Because the simple truth is, even you can see the professors at law and even senior advocates at law telling you that even there are flaws in the so-called law that governs the land. So what do you make of that? Thank you.
What do you make of that, he says? 30 seconds exactly. Victor, 30 seconds. Hello, Victor.
Good evening, Amoimo.
Yes, good evening. It's Sandra. Go ahead. You've got 30 seconds.
My own opinion is that Nigerian government, the federal government as a whole, why is it that any peaceful protest, they declare those people as a terrorist? Why some people, the protests, are they going with arms? Why Boko Haram? Have Boko Haram gone to court for Nigeria for once? Have Fulani herdsmen gone to court for Nigeria for once? So why is it that anybody who is in peaceful protest is person as terrorist group? Why terrorist group are there terrorizing the nation?
All right, Victor, let me talk to Remy. Hello, Remy. Thanks for calling us. Why are other groups not going to court? Remy, what are your thoughts?
How are you doing, Sandra?
I'm very well. You've got 30 seconds.
I think the prof said something profound.
Okay.
He said there is no law that will make sense to anyone who chooses to be a god on earth.
Yeah.
And you made mention of Malami making reference to that of Atari Dokubo, which doesn't really hold water to me. Because that of Atari Dokubo, on different cases, court never granted him bail, unlike Ezazaki. So you get, till it got the Supreme Court, Dokubo wasn't granted bail, which is quite different. So we shouldn't even keep re-echoing that. I don't want to use the dirty word. We shouldn't keep re-echoing that. So it doesn't make any sense.
All right, Remy, thanks for calling. Okikiade is in Prayer City. Hello, sir. Thanks for calling.
Thank you very much.
Good evening. I've got 30 seconds for you.
Yeah, the 30 seconds I will only use it for your accolade. You are first of all English major and also a PhD in law. Everything I had this evening, I am really proud of you. Your parents will be proud of you. God bless you.
All right, Okikiade. Thank you so much. I appreciate that. Okay, we've got Charles in Surulere. Hello, Charles. Yes. Thanks for calling me. Go ahead.
Okay. I'm concerned the terrorist group of a team. I want to ask one question. Does this group exist when Buhari government come in power? Abi has been existing during Obasanjo and the Jonathan time? Are they not be protesting? Did they declare them terrorists? Or does Buhari group with the members that is destroying Nigeria?
No, let's not do that. Let's be very careful about what exactly we decide to say on the show. Our last call is from Prince YS. Prince YS, you've got 30 seconds. Share your thoughts.
How are you, Sandra?
I'm very well.
All our lawyer that don't make that the professor did not say the right thing. Why am I saying this? Somebody say I want to change the government, and you are telling me just overlook that.
No, he said it. He did not. He said he did not act. Are you talking about Shore or El Zakzaki?
I'm talking about
Shore. Yes, he said. What did Shore do? He said he didn't do. And until you do, you've not done anything. So he shouldn't have been arrested. That's what he said.
Looking at him until he commits offense before we can arrest him.
So for everything you say on Nigeria Info on air, should you be arrested?
Let me tell you. What's the word? Was run the JSS to getting arrested. The best thing now to do it was the JSS to court. Either they bail him or they remind him he has committed an offense against the nation.
I see.
Let me tell you, This man never recognized anybody.
Prince YS, I'm out of time, unfortunately, but call me on the other side of 6. Let's talk about this. Do you believe that what Omoyele Sowore said was treasonous? Were his comments treasonous? Call me on the other side of 6 immediately after the 6 o'clock news. 01277 0993 01277 1993 and 01277 2993 as well as 01277 3993.
99.3
Nigeria Info, your number one talk, news, and sports station in the nation. Yes, sir. Only 99.3 Nigeria Info.
Nigeria Info.